Ritu, you're on.
Hi, everyone. Welcome to the training today. We'll get started in just a couple minutes. Thanks so much for being here today.
Hola a todos, vamos a comenzar en unos minutos más. Muchísimas gracias por estar aquí y bienvenidos.
Okay, I think we can go ahead and get started. Again, thanks for being here this evening to join us for this webinar. We're here today to talk to you all about promoting safe early care and education for all.
Muchísimas gracias por estar aquí. Le queremos dar la bienvenida para darles una presentación acerca de la seguridad para todos.
Specifically, we'll be discussing a new California law called AB 495 and the requirements that it imposes on childcare providers.
Vamos a estar hablando de la nueva ley que va a estar ayudando a los cuidadores domésticos.
And now we're going to provide some language access instructions.
Ahora le vamos a proveer unas instrucciones de cómo accesar al lenguaje. Hello, my name is Alondra, and me and Camila are going to be your interpreters for today. We'll be offering interpretation into Spanish and English. Once the function is on, if you're your computer, you will see a globe at the bottom of your screen. Click on it and select your preferred language. If you're on your mobile device, you will have to scroll all the way down on a menu that appears at the bottom of your screen and click on the three dots. Select your preferred language and click Done. Please remember to mute original audio unless we're fully bilingual and to speak slowly and clearly so that the interpreters can relay your full message. Thank you.
Hola, mi nombre es Camelia. Alondra y yo seremos sus intérpretes en el día de hoy. Vamos a estar ofreciendo interpretación al español. Una vez la función esté encendida, si está en su computadora, va a haber un globo en la parte de abajo de la pantalla. Le hace clic y luego selecciona su idioma de preferencia. Si está en su dispositivo móvil, va a tener que deslizar el menú de la parte inferior hacia el lado izquierdo hasta que vea los tres puntos. Le hace clic y luego selecciona su idioma de preferencia y le da a Done o Hecho. Por favor, recuerde silenciar el audio original, hablar lenta y claramente para que los intérpretes puedan dar su mensaje completo. Gracias.
Okay, we'll now go ahead and turn the language channel on. So please select your appropriate language.
Ritu, there's a question in the chat asking, or in the Q&A, that the globe is not available. So for those of you who are looking for interpretation, you'll need to click the More button with the three dots and select the interpretation.
Okay. Also, please note that you will be able to choose the screen that you want to view. So if you want to see the slides in English, there's a tab at the top that says English slides. If you want to view them in Spanish, there's a tab that says Presentación en Español. Okay, so hopefully everybody is in the right channel now. I wanted to just quickly explain who is providing this presentation for you today. This is being provided by a partnership known as All In for Safe Schools. This is a California-based campaign that brings together early childhood education and K through 12 nonprofit leaders. Our goal is to support educators in creating welcoming, inclusive, and affirming spaces, especially for children in immigrant families and LGBTQ plus students. You can learn more about this partnership at the website allinforsafeschools.org. Next slide, please. This is just a brief disclaimer to let you know that the presentation today is a general overview. It's for informational purposes only. It is not all inclusive. It doesn't mean we're providing legal advice to you, and attending this presentation doesn't create a lawyer-client relationship. Um, Later in this webinar, you will get our contact information for Public Counsel and have information about how to apply for our services. Okay, and next slide. So now we're on introductions. My name is Ritu Mahajan. I'm the directing attorney of Public Counsel's Community Development Project. For those that aren't aware, Public Counsel is a nonprofit law firm. We provide free legal assistance to small business owners and nonprofits, including childcare providers. We are presenting this webinar today with Andrea Fernandez Mendoza, who I'll turn it over to now to provide her introduction.
Good evening, everyone. I'm excited to see so many people on our Zoom this evening. Again, my name is Andrea Fernandez Mendoza. I've been with California Children's Academy for over 30 years, and I've worked, our program is a state-funded program, full day, full year, and it's we hold 2 contracts, center-based CCTR and CSPP funding. We serve infants, toddlers, and preschoolers at 15 locations across Los Angeles County. I'm going to pause because I know the translation is catching up with me. I also serve on the board of Every Child California. I'm a lead advocate for ECE Voices, the incoming chair of the Los Angeles Child Care Planning Committee, and several other hats that I wear in the ECE world. But I'm really happy to be here to share the information that we are presenting to you tonight. Thank you, Ritu. I'm going to hand it back to you.
Thanks, Andrea. Next slide, please. Okay, so I'm going to turn it over to my colleague Cassidy Bennett, who works with me at Public Counsel. She will be presenting on the next few slides, as well as myself and my other colleague, Kaho Maeda.
Thank you, Ritu and Andrea. Thanks everybody for being here tonight. It will start with the overview of what we're going to cover. We'll start with background. We'll then go to AB 495 and that overview. We'll talk about who is covered by AB 495. What does AB 495 require from you as childcare providers? Then we'll discuss the model policies provided by this law. And then we'll go into what to do if immigration agents are at the door, as that is one of the things covered by this law. We'll talk about a compliance checklist that will hopefully be helpful for you. Then we'll go back into takeaways from today, resources that we'll continue to provide you, and we'll end with Q&A. So please put your questions in the question and answer box on Zoom. And as much as possible, save your questions or make your questions as general as possible, just because we are recording this. And there are multiple people in this webinar, and so we just want to make sure that you're not revealing anything confidential that you wouldn't want to. So please keep those questions general, but you can put them in the chat, or sorry, in the question and answer box throughout the presentation. And next slide, please. So we'd love to start with a grounding. we just want to remind you that as we move through today's training, your well-being matters. Some of what we'll cover, such as the threat of deportation, risks to your safety, to the safety of the families of the kids you work with, they can bring up really strong emotions or stress or painful memories. And it's completely normal to feel overwhelmed or stressed or afraid when speaking about these things or thinking about them, hearing about them. So, as you are part of the webinar tonight, our goal is to support you and help you understand what needs you need to meet, not to add stress. So just remember that you're not alone and take care of yourself. If you need to step away or just stand up and stretch or go get water or take a deep breath, please do. Remember that we're recording this and we will have resources to follow up with. So it's okay if you miss a couple slides because you need to step away and take care of yourself. Next slide, please. So for an example of some things that we can do right now together, and then you can do throughout the training if you need them, there's a couple options here. So I'll just go over them, but feel free to start doing them while we're talking about them. If you want to choose one and focus on it, whatever feels best for you tonight. So the first is gentle breathing. And that's just inhaling deeply through your nose and slowly releasing the air through your mouth. So just really more conscious inhales and exhales. Do it again. Fill your lungs up like a balloon and then slowly release the air out. The second one is releasing your shoulders. So this is something that can be helpful if you're noticing like, ooh, my shoulders are very tense. So let's move them a little bit. You can gently raise their shoulders towards your ears as you inhale. And then as you exhale, let them drop like you're releasing a sigh. And then just repeat that. Inhale, lift. Exhale, release. The last one is to relax your jaw. And sometimes we're just clenching our jaws without realizing it. So if you're in a space where you feel comfortable, just move your jaw gently from side to side. You can also open your mouth slightly as if you were yawning and just kind of allow that tension to melt away. Even just noticing it in your jaw can help you realize that you need to relax it. So let's take just a few more seconds, choose one of those things, focus on it a little bit more for a moment, just as we start before this intense topic tonight. So again, please feel free to come back to these at any time that you need them tonight, or hopefully as you move forward as well. They're just helpful exercises. All right, next slide, please.
So, Cassidy, I'll just step in here real quick. So, we wanted to turn it over to Andrea Mendoza, who introduced herself a couple minutes ago, to provide some context as to why this webinar is being provided today, as well as to underscore all that we've been through as a community in the past year and a half, from her personal experience, being in this sector for so many years. And I'll pass it to Andrea.
Thank you, Ritu. Good evening again, everyone. I see many familiar names on the Zoom, and I appreciate the opportunity to speak with you today. We often talk about early care and education centers as spaces of joy, curiosity, and foundational learning. But for many providers across California, our daily realities include managing a heavy layer of community stress, uncertainty, and fear. With California AB 495, the Family Preparedness Act, our state has taken a historic leap in recognizing that early childhood education safety extends far beyond our classroom walls. The question is no longer, can we protect our families from systemic disruptions, but how? And how do we implement these new state-mandated protections effectively, uniformly, and compassionately? Our primary goal as educators is to provide a safe, nurturing environment where children can thrive. But true safety doesn't stop at the classroom door. It requires a systemic framework that protects children and families when the world around them experiences a crisis. AB 495 is not just an administrative policy, but a vital shield for our families and a necessary blueprint for our workforce. In our communities, immigration enforcement and local instability are not abstract political debates. They are events that are happening right outside our windows. We at CCA have experienced immigration enforcement activity in our immediate surrounding areas around our programs, our centers, on multiple occasions. And every single time, it casts a shadow of fear over the simple act of dropping off or picking up a child from school, or even coming to or from work. When we have the knowledge of immigration enforcement nearby, the site goes on lockdown. We have a no authorized visitor policy that we beefed up with the passage of AB 49 and added no trespassing, private property signage, and video intercom entry locks at our centers to protect everyone's safety. This is a reality for us. This is something that happens in the community that we are in, and so we had to take proactive measures to make sure everyone was kept safe. When immigration enforcement is nearby, our staff call our administrative delegates, that would be myself, and if I'm not available, we have a hierarchy of people to call. And we notify all affected families via our Learning Genie communication system. We operate on the assumption that it is a credible threat until we prove otherwise. And we follow our agency's policies and procedures until the situation is resolved. We have faced the heartbreaking reality of a parent being detained on live TV by immigration. Imagine the feelings of crisis when it's closing time and a parent doesn't return to pick up their child. Then, having to support the remaining family members as they readjust their lives to a new reality. We have had to do this. We've had to send our early childhood mental health and family service teams in to support not only the families that have been left behind, having this traumatic event happening to their family, but also to the classrooms with resources, books, and activities to help both the staff and the children and their families process all the big feelings they understandably have. Our staff are early childhood educators, not legal experts or crisis responders. Yet, when those immigration enforcement actions occur nearby, they are thrust into an impossible ultimatum. Staff themselves have been terrified, balancing their instincts to shelter in place and protect the children in their care against the systemic fear of how these interactions might impact their personal lives. We have had many staff and their family members lose their jobs due to systematic delays in reviewing their work permits, their paperwork. We've done the best we could to connect those families and staff with resources to help them navigate the system. But all of us have been put under undue stress, and many have lost their livelihoods because of this crisis. At CCA, we have had to independently develop, update, and train our staff on how to handle these high-stress scenarios. It is very important that everyone in your program, in your family childcare home, from the teacher assistants to the custodians to the supervisors to the parents, that they know what to do when a threat appears and who to call. Something as simple as not opening the door for another parent coming in the center, knowing who should be there or not. All of those, we have to have a conversation with our families and tell them, you can't hold the door open for another person. You don't know who they are. And especially to keep the center protected, it may come across as rude, but we've had to make sure everyone from the custodians to the parents to the supervisors know what to do when that threat appears. Because when crisis hit, fear breeds paralysis. They freeze. So staff and families need immediate, clear, and compassionate direction. AB 495 model policies guide us and have provided a mechanism to offer concrete guidance, so no program or family is left guessing about their rights or their children's safety during an enforcement action. A little bit later, we'll talk about what it looks like in our program and some of the policies that we could put in place to make that happen and to ensure that everyone knows what to do when they're faced with this situation. I'm going to turn it back over to Ritu.
Thank you, Andrea, for your inspiring words and your work in this area. It's really something to look up to, and I appreciate you being here. I'm going to pass it back to Cassidy, who will go through some of the next slides again to talk about 495, which is why we're here today. And we really want you to walk away with tools to help you understand how to comply with this law. And again, you're not alone. We're all here to support you. And we will provide information at the end about how you can access our free legal services as a child care provider.
Thank you, Ritu. And yes, thank you, Andrea. And thank you to all of you here for the incredible work that you do. Yes, hope you walk away feeling like you have a lot more knowledge tonight. So, as I said, we'll start with our overview of what is AB 495. And next slide, please. So last year, California passed a new law called the Family Preparedness Act of 2005, which we'll be calling AB 495, to protect family privacy and children's well-being. It became effective January 1st of this year, 2026. The law is designed to ensure the safety and privacy of children and families, as well as the accessibility of childcare homes and centers, regardless of a family's immigration status. It was created to protect the continuity of care for children, to reduce fear for families, help providers respond lawfully, to preserve trust in childcare settings, and to keep the focus on child safety rather than enforcement. The law required the California Attorney General to issue model policies for childcare providers, and only certain types of providers are required to adopt these policies. In the coming slides, we'll tell you which providers this law explicitly applies to and when those providers are required to adopt the model policies. However, it is recommended that all providers adopt these or similar policies to partner in creating safe and protective environments for children and families and to comply with the law. This law also encourages families to plan for emergencies. For example, talking about who will care for a child in the event that a parent is detained. And as it says on the slide, you're required to adopt these policies by July 1st, 2026. Next slide, please. So AB 495 equips childcare providers with clear policies to safeguard family privacy and shield children from the impacts of immigration enforcement. Before AB 495, there was no comprehensive childcare specific immigration resource or response framework. There were inconsistent practices across facilities, less clarity for staff responding to ICE requests, and a limited formal preparedness expectations. After AB 495, there are now clear model policies for childcare providers. There is stronger emergency contact planning. It generally prohibits collection of information unless legally required. and it provides a formal response guidance for enforcement requests. All right, next slide, please. So who is covered by AB 495? I mentioned that it doesn't apply to everybody, so who does it apply to? And yes, next slide, please. So while AB 495 specifically requires certain childcare businesses to adopt the Attorney General's model policies, which don't worry, we'll talk about later in the presentation, it is recommended that all childcare providers adopt these or similar policies to ensure that children and families are protected from the impacts of immigration enforcement. So who must follow? California state preschool programs, both licensed and license exempt, must adopt policies by July 1st, 2026. A license exempt California state preschool program facility refers to the California State Preschool Program classroom operated by LEAs under contract with the California Department of Education that meet additional operating requirements in a school building that meet specified conditions. So that's one of the programs that's covered. The licensed child daycare facilities also, and most family child care homes also must adopt the model policies or use equivalent protections by July 1st, 2026 as well. And that refers to all licensed childcare facilities in California, including licensed California state preschool programs. So that includes most family childcare homes, most preschools, and other early childhood education facilities in California. All childcare providers must review their own policies to make sure they don't conflict with the model policies, and that any information, policies, or guidance that the facility has provided to parents or other authorized representatives is revised before releasing them again. For the last four on the slide, it's just recommended that you adopt the policies. It is not required. Though again, it's recommended.
Cassidy, I wanted to clarify something. So I understand that 495 applies to California state preschool programs that are licensed and license exempt, as well as licensed childcare centers and homes. But AB 495 has a lot of requirements in addition to the policy requirement. My understanding that the requirement to adopt the model Attorney General policies by July 1st is only applicable to California state preschool programs.
Yes. The California, thank you, Ritu, for clarifying. The California state preschool programs must adopt the actual model policies. The second bullet point here, licensed childcare centers and homes must adopt either the model policy or an equivalent protection. So it may be easier for you to adopt the model policy in order to comply, but you are not technically required to. You could use an equivalent protection, in which case you need to very carefully review your current policy to make sure it does not conflict with the model policies, provides equivalent protections. So thank you for clarifying that difference. Did you want to add, Ritu?
No, I was just going to say, okay, so I think we can turn to the next slides, but we'll just slow down a little bit for the interpreters.
Yes.
No.
And yes, sorry, the last four, it's just recommended that you adopt the policies. And that's very limited groups. So do please reach out to an attorney if you're unclear on whether or not it applies to your childcare business. Okay, thank you. Next slide. So what does following or having AB 495 apply to you? What does that require? Next slide, please. So we'll discuss each of these requirements in more detail in the next slides, but here are the ways that you can comply with the law. Only ask for necessary information. Do not share personal information about children and their families unless required or authorized by law. Require immigration agents to present a judicial warrant before entry into your business. Ask parents or guardians to update their emergency contact information regularly. Report any law enforcement visits or information requests. And share the California Attorney General model policies with the parents and guardians you work with. So this can hopefully be a little reference guide for you, but again, we'll go in depth on all of these. Next slide, please. So only asking for necessary information. The strongest protection of the information that you have is often not collecting any unnecessary sensitive information to begin with. So unless the law or state-supported educational program rules require that you collect certain information, do not do so. Do not collect information about immigration status, citizenship status, alien registration numbers, social security numbers, or any unnecessary identity documents. Next slide, please. So that might seem like a lot not to ask for. So what can you ask for instead? When possible, collect documents that reveal less personal information, but still allow you to understand the information that you do need. So that could be a form of alternative proof of relationship to the child. For example, a court order or a guardianship documentation, or a caregiver authorization affidavit. You can ask for flexible work verification methods, such as pay stubs, or if they're self-employed, it could be tax returns or business ledgers. You can ask for, just in general, documents that don't reveal birthplace or status. Remember that any information that you do collect must be kept confidential and secure. And providers should limit your staff access to records as much as possible. If you can use one administrator for all the requests, make sure you're never casually discussing family information, and document any unusual requests that you get. You also should be discarding sensitive information when it's no longer needed. So again, that may be specific to the rules of your funding or the way you interact with certain laws. So you'll want to be aware of a few different things and what you can discard and how quickly. But that's something that we can talk to you all about as well. Next slide, please. When you are asked to share information, you should only be sharing what is required or authorized by law. So do not share personal information about children or their families unless required or authorized by law. There are a couple situations in which your childcare business would be required or authorized to share information, including receiving a valid judicial warrant, a judicial subpoena, or a court order, which we'll show you an example of, or if the disclosure is directly connected with administering the program, like receiving your funds or other things that you may need, or you have handwritten permission directly from the parent or guardian. Next slide, please. This is a whole training in and of itself, but we just want to remind you that you should require immigration agents to present judicial warrants before entry. So not every part of your facility is open to the public. And it's very important to know the difference between public and private spaces in your facility because you have the constitutional right to deny entry to private spaces without a valid judicial warrant or court order. So, what Andrea was talking about earlier, where you have to ask parents to very awkwardly not let other people into the building behind you, which is just not something that most of us do naturally, that helps influence these ideas of a private area versus a public area. And unfortunately, it's important right now to enforce those. Just again, just those awkward interactions. But a private area is a space where individuals have a reasonable expectation of privacy. And that may include classrooms, staff offices, records rooms, staff-only workspaces, areas with children under supervision, etc. That can be very specific to your building and your setup. If an immigration agent comes to your childcare business and asks to enter, you can require that the agent show you a judicial warrant or court order before you let them in to those private spaces. So that's the benefit of having those private areas. If you receive a warrant or a court order, you'll need to review it yourself, and I'll talk a little bit about it, what it looks like on the next page. A public area, oh, sorry, one more on this slide. Thank you. A public area may include your lobbies, waiting areas, a parking lot that's open to the public. Think about like, again, like if you go to the doctor's office and you're just sitting in the waiting area before you're taken back. Those are areas where the public can enter without permission. So if anyone in the public is allowed to enter that area, then an immigration or law enforcement agent may also enter that area without a judicial warrant or court order during your normal business hours. All right, now the next slide, please. So this is the example of a judicial warrant, and this is something that you do have to comply with. And there can be consequences for failing to comply. So it's something that you'll want to understand how to review if it's received. It's issued by a judicial court and signed by a judge. So you can see on this warrant in the top right, it says United States District Court. So we see that it was issued by a court. Then in the bottom right, you see a signature of a judge. You see it says U.S. Magistrate Judge. So issued by a judicial court and signed by a judge. It authorizes an arrest, seizure, or search, depending on what the scope it is. So you want to look, after you've looked at who's issued it, was it a court? Okay. Now you're going to look at where's the address? What's the scope of the search? And when you look at the address, is it the correct address? Is that your building? If you have multiple locations, are they at the correct location? Is the name correct? You need to verify those things because if there is incorrect information there, it could mean that it's not a valid warrant for your location. Then you're going to look at which one of those things it authorizes. Is it a search of the facility? Is it an arrest of someone? Is it a seizure of something like paperwork or other evidence? And if it's authorizing a search, especially, you want to be really clear where. So is it saying childcare room 1 and director's office? If so, you want to limit only to where exactly what the warrant says. Then you can look at the date it was signed and by when it needs to be executed. So they have to execute a warrant, meaning they have to take the paper and bring it to the facility within 14 days. If more than 14 days have elapsed, it's an expired warrant, it's not valid. Again, then you'll get to the bottom and see if it's actually that judge. If it is valid, you do have to comply, and you will want to make sure that you comply, but again, limit them as much as possible. If the judicial warrant doesn't authorize a search, but actually authorizes an arrest of a particular individual, you can actually ask that individual to come to the front of the school rather than giving an officer access to enter the school. You do not want to provide an officer access that can then be construed as consent to additional searches, even if they didn't have a warrant for that to begin with. So make sure to keep them as out of your space as possible. If it is not valid, if any one of these things is not valid, you can deny the request. And if it authorizes a search only of a particular space in your school, they cannot use it as a basis for searching other parts of your space. And you can object if the law enforcement officer goes beyond that scope. All right, next slide, please. So another thing I mentioned was asking parents and guardians to update their emergency contact information regularly. So as we all know, your emergency contact can change. And so that is the case for your parents as well. So routinely check in with them to review and update the emergency contact information they have provided so you can ensure that there is always a trusted adult who can care for the child if something were to happen to the parent or guardian. And then you're also going to encourage parents to plan for immigration enforcement related emergencies. And we will provide a link to our family preparedness guide for more information. That's something that you can provide to your parents to help them get ready. It goes over what they need to do and what they should be thinking about, and what they may need to talk to their kids about as well. Next slide, please. So under AB 495, there's also this requirement of reporting law enforcement visits and information requests. So if you were to receive a warrant like that, or if there is any type of law enforcement visit to your facility, licensed childcare facilities must report requests for information or access by an officer or employee of a law enforcement agency to the Attorney General and to the California Department of Social Services. So there is LIC 624 for childcare centers, or LIC 624B for family child care homes. And again, we know this is a lot of information and things to track, so don't forget that we'll be providing it after, so that you know which forms to follow up with. And that's so that they can track how much interference law enforcement is trying to have on childcare centers. And with the next slide, I will pass it back to Ritu.
Okay. Thank you everyone for bearing with us. I know this is a lot of information. Before I talk, so everything Cassidy has mentioned related to, being able to assess if something is a judicial warrant, being able to make sure that you have updated emergency contact info, making sure you're not sharing information about families and children without, a proper judicial order. All of that applies to, California state preschool providers and also family childcare homes and childcare centers that don't provide state preschool. So all of those pieces apply to, a lot of different types of childcare providers. The thing about model policies, which I was just researching because it is very confusing. So, what the law requires, and I'm going to say it again to be very clear, is that if you're operating a California state preschool program, whether it's licensed or license exempt, you have to adopt either the model policies that the Attorney General has put out, and we'll put a link to it, or something similar by July 1st. If you are a childcare provider that provides, family childcare that's licensed or a childcare center, but you're not doing state preschool, you are not required to adopt the model policies. But if you have policies, right, that relate to any of these issues, they cannot be inconsistent with the Attorney General model policies. So I'm going to say that one more time. So if you're a California state preschool program, you have to adopt model policies or something like the model policies by July 1st. If you're not a California state preschool program, but you provide licensed family childcare or licensed childcare center, you don't have to adopt model policies at all. But if you do have policies on these issues, you have to make sure that they are not inconsistent with the model policies. So I know it's confusing, but I will keep trying to remind us of that. We recommend that all of you, whether or not you operate a state preschool program, have policies to plan for this kind of situation where immigration agents are showing up at your door unannounced, or people, these agents are requesting information about families that you care for. Because as Andrea was saying, these situations are really stressful. And if you don't have a plan in place for how to deal with it, it's going to be even more difficult to navigate the situation. Public Counsel, we have a guide that has model policies that you're welcome to use. They're very similar to the Attorney General policies. We have templates, you can adopt them to your own program, but we do think it's a good idea for all providers to have some kind of policy in place, right, for what to do when these situations arise. So in the next few slides, I'm going to talk about what the Attorney General model policies look like. And like I said, only the state preschool programs have to adopt these by July 1st, but it's good for all of us to have policies like this. Yes, I will slow down. Okay, next slide, please. And I'll wait 30 seconds as well. Okay, next slide. Okay, so this is just a cut and paste of what the Attorney General model policies look like when it comes to collecting and retaining information. So basically, the Attorney General policies explain that your childcare facility should have a procedure in place, right? So if anytime an agent is requesting sensitive information about the families you care for, that you have a process that you're going to follow to respond to that kind of request. In general, if you do have information, sensitive information about a family's, immigration status, citizenship status, you're not to use that information to discriminate against the family or to, disenroll a family, or to make decisions about enrollment. If a family doesn't want to provide that information, again, it's not a reason to discriminate against that family or decide whether or not to enroll them based on their decision not to provide that information to you. And big picture, you're to treat all children, regardless of their status, their origin, their ethnicity, equal, right? So everybody should be treated the same. Next slide, please. Again, the second part of the model policy. So again, as a facility, you shouldn't be requesting information about child citizenship status or immigration status unless you're required to do so by like some funding you receive or by some law. Um, and if you do have eligibility criteria that you need to meet for enrollment, maybe there's another way for you to meet that criteria without revealing someone's immigration status. So as Cassidy mentioned, think about other ways that you can meet that criteria, that doesn't implicate someone's legal status. Um, and also provide other documents that a family could provide. Again, so for example, if you need to establish someone's birth, I know birth certificate obviously is the easiest way to do that, but if there's another way that somebody can establish that, because the birth certificate reveals, for example, that the child's born in another country and that could, negatively impact them, figure out if there's a way, right, to meet your criteria in these alternative manners. Again, you should not be collecting information about family social security numbers either. Um, the goal here is don't collect the information unless you really need it to meet funding requirements or some other law that you're trying to meet the needs of. Because if you have the information, there's always a chance that it can be leaked or that someone can ask to see it. And of course, if someone does ask to see it, you'd always have the ability to challenge that request legally, but it's best to just not have the information in the first place. Okay, next slide, please. Um, so this is about sharing information. As we've already said, you're not to share the information, the personal information about children and their families without the consent of the family, um, unless you're required to share this information by law or if it's directly connected with administering the program. Same thing applies for employees. In general, do not be sharing information about your employees, unless you've been given a court order, such as a judicial warrant or subpoena. If you have been given a court order, you can always ask public counsel or a lawyer to review it and give you advice on whether or not it requires you to turn over information. Um, Regarding employee records, it's always possible that the government can conduct an I-9 audit, which is I-9 is a form you have to have for every employee that you hire in the United States. This information about not sharing records does not apply to I-9 audits. But if you do get an I-9 audit, or notice of inspection related to an I-9, please contact public counsel or a lawyer before you respond to it. Um, and again, this just provides a process that you can follow if someone asks you for information about a child or your staff. So again, you shouldn't just be handing over the information, right? You should make a copy of who's asking for it, have an administrator at your program that you make aware of the request for the information. You contact a lawyer, before you comply with any legal request for the information. So you have a process in place that you're following. Next slide, please. And this is a big one, and it kind of relates to what Cassidy was talking about, judicial warrants. So if an agent tries to access your facility, again, you're not just going to let them enter, you're going to have a process in place where an administrator meets them at the door, hopefully, asks to see whether they have any judicial warrant to enter. And if they have a warrant, someone has to be trained to review it and see if it's really a valid judicial warrant. And if they do, have a warrant, you do have to allow them to enter. But as we said, you want to follow them and make sure, I'm sorry, make sure they're staying in the scope of the warrant. Next slide, please. And these are just, again, best practices to follow. Make a copy of any documents provided by the agent, and, describe what warrant they provided, and document and record everything that's being given to you. Next slide, please. Again, this is more about documentation and the information you should be recording about the interaction with the agent. Next slide, please. And if an agent does request information or shows up at your facility, you do have an obligation to let licensing know, as well as the Attorney General. And there's different forms you can fill out to let them know, which are also linked in this webinar. And you also have an obligation to update your policies over time as needed. And Lisa put the model policies in the chat. Next slide, please. Okay, so I know this is a lot of information. I can see a lot of Q&A. We just have a little bit more to get through. This is more practical advice, but before we get to that, I will turn it over quickly to Andrea. So Andrea has experience as a childcare, as someone who operates a childcare, program on how to implement model policies. So I'm going to turn it to her.
So I know we are a little stretched for time, so I'm going to go through my information really relatively as quickly and slowly so interpretation can keep up. We used the model policies provided in AB 495 to create our organization's policies and procedures. We literally went through and we edited the guidance to fit our program. At CCA, we are a Title V program having both CCTR and CSPP. So we already had policies in place to address confidentiality for children and families, and staff, but we added the references in to include the stronger language that was included in AB 495, and we communicated these expectations to all program staff. We held a all staff training in March where we explained to them, we already had a no visitor policy, no unauthorized visitors on campus policy. So we dug a little deeper and we trained everyone on what to do if ICE shows up at the door, who to call, and so forth. So one thing I need to stress that will make or break it for your program is that everyone on your team needs to know this. We take the items listed in the guidance as common sense, but they clearly need to be identified and shared with everyone in your program. Everyone needs to know the requirements of AB 495 because there is a list and that there was a guide that you can follow. Outline each of the guidance so that they, what we did was we outlined the guidance and we put it in a written acknowledgement that they received, that our staff received it and they understood the policies, what it meant to their component. So for example, our eligibility staff, our teaching staff, and then how they implemented it in their classrooms or at their centers. It helps protect them, the families, and your program. For example, all staff know that any immigration enforcement is immediately reported to me. I am the designee in our policy and procedure, and all staff have been trained on this. There are clear steps to proceed from initial contact to the end of the crisis. And they know that when that happens, they do not open the door. The agent slides the information under the door, and then that information gets sent immediately to me, and I send it to our agency's legal counsel for guidance. The door stays closed. A key component in our implementation is the proactive distribution of the Family Preparedness Plan. That is part of the guidance and the requirement. We have built this into our enrollment and recertification process. The packet will be given to families, hand-delivered at their enrollment or their recertification. It's going to be posted on our website, which we are currently uploading, and it will be made available on the on-site parent resource boards. So they have a copy at the site, they have a copy that they can download, and they are given a copy every time they come in to recertify or to enroll. Every family is supported in establishing a designated emergency contact list with legal directives and authorized pickup protocols before the crisis occurs, ensuring that the children are always in trusted hands. On our agency calendar, which is something I implement every year, every first Friday of the month, all classrooms review the emergency card information with the families to update the numbers and contacts, replace them, change them, or add additional persons. This ensures we have current, up-to-date information for every single child. When we're no longer operating in a space of paralyzing fear, we're able to be proactive and attack it from the front end to protect ourselves. So my best advice to you would be to use those model policies that they provided, fill in your program's name, make it fit your program, and then make that your policy. And if your program requires you to get board approval, present it to the board. I know that my board was really excited to hear that we had made these changes and had step-by-step policies on what to do if immigration shows up at our doorstep. So again, I'm happy to share our information, and if you have any questions, please feel free. Ritu?
Thanks, Andrea. I'm going to turn it to Kaho to close us out. And thanks everyone for your attention to these issues.
Thanks, Ritu. Yes, so I am going to talk about recommended practices for your childcare program. Andrea just gave some wonderful examples of how everything that we're talking about today can actually be implemented in practice in order to keep your families and your staff feeling safe and prepared. So these are a couple of recommended practices. The first is to help parents and guardians with their family preparedness plans in case of any immigration-related emergencies. That might look like updating emergency contacts regularly, identifying any backup caregivers, keeping any forms that you receive from your family's current, and then always making sure to follow any written family instructions that you've received. You also, like Andrea mentioned, you want to ensure that your staff understand their rights when interacting with immigration enforcement. As Cassidy explained earlier in the presentation, you want them to know how to verify judicial warrants and when to contact legal counsel. You can also reference Public Counsel's Interactions with Immigration Enforcement Guide for further information. We're going to send out the presentation and everything is linked throughout the presentation, so you'll get all of the resources then. You, of course, also want to prioritize and safeguard the child's emotional well-being if a parent is detained or cannot arrive for pickup. You all are definitely the professionals here, but making sure to stay calm with the child, using approved emergency contacts, verifying the person picking up the child before release, verifying their identity, notifying leadership within your organization, and then documenting any actions that might be taken. And as Ritu mentioned earlier, you just want to also make sure that immigration concerns are not a reason to deny or discourage enrollment or services. You need to treat all children and families equally, and make sure that you're applying documentation rules fairly. Also, as we have mentioned today, you don't want to wait until immigration enforcement comes to prepare. The strongest protection for children and families is having clear systems already in place. Like I mentioned, this also helps staff respond calmly and lawfully. And we can move to the next slide, please. So what does this look like in practice if immigration agents are actually at your door? We know this moment can be very scary. So first you want to stay calm and make sure you don't run. If you run, this can be taken as evidence of wrongdoing and cause for arrest. Next, you should contact the authorized person that's outlined in your policies. If you see ICE outside, then have the authorized person go out by themselves to speak with the ICE agents and confirm their identities. You want to try to avoid creating fear or confusion, whether it be within your staff or with the children in your care. If the ICE agent is outside or outside the door, the authorized person can say, "You do not have permission to enter private areas without a judicial warrant. Please remain outside in this designated area." If the agent has some kind of documentation, the authorized person will inspect the provided documentation. Is it a search warrant, an arrest warrant? You want to make sure that you're reading these documents with specificity because they need a valid judicial warrant in order to search private areas, as Cassidy was explaining earlier. If the agents do not have a judicial warrant, you can say that we have a policy of denying access without a valid judicial warrant. Again, they're not allowed to enter without a valid judicial warrant. If they do have a valid judicial warrant, you want to double check it. And then, as Cassidy explained, limit the search to the scope of the warrant. So if there's only one room that's listed on the warrant, making sure that the search conducted by the ICE agents is limited to that room. You also want to accompany them the entire time and, as best you can, document the whole thing. And then a few extra tips. You don't want to release any information about clients, staff, or others unless the warrant or subpoena specifically requires you to do so. You also cannot help ICE agents sort people by immigration status or what country they're from. If they come with an administrative warrant with an employee's name on it, you're not required to say if the employee is working that day or not. And you also do not have to take the ICE agent to that employee. And if they do try to take something from your business that is vital to your business, you can explain why it's vital and ask for permission to photocopy it before the original is seized. So that might be some important documents for your business. You can ask for permission to photocopy it before it's taken. And then if you want to object to any search that is outside of the scope of what is written on that valid judicial warrant, you can make that objection, simply present the objection, but don't engage in any debate or argument. Just make note of the objection. Your attorney should handle that later. We can jump to the next slide, please. Okay, relatedly, if an immigration agent stops you and questions you, this might be outside of your place of business, but we wanted to share this information as well, just so you all have it. If they approach you and say, we want to ask you a couple of questions, the first question that you always want to ask is asking if you are free to leave. If they say yes, then you can calmly walk away. If they say you are not free to leave and you don't have valid immigration documents, you want to make sure that you're only showing documents if asked. Oh, sorry. If you do have valid immigration documents, you want to show them only if you are asked. If you do not have valid immigration documents, you are allowed to refuse to answer. And so you can say, I do not consent to any searches. And then you can also state, I'm going to remain silent, and then do exactly that, stay silent. It's important to note that you do not have to answer questions about your immigration status, where you were born, where you live, where you are from, or whether you have documents. So always keep that in mind if you do encounter an ICE agent. Then we can flip to the next slide, please. Great. Next, we are going to run through a quick compliance checklist. We just wanted to synthesize all of the information that we've given to you today. So after this presentation, this is our recommendation to run through these action items. So the first is to read the California Attorney General's guidance on compliance with AB 495. Second, you want to make sure you have adopted AB 495 model policies or something similar, depending on what kind of childcare you are running. So again, if you are California State Preschool Program, you are required to adopt the model policies or something very similar to the model policies by July 1st, 2026. And if you are a licensed child care center or home, you are highly encouraged to adopt the model policies or very similar policies. You need to make sure that your policies comply with and are not inconsistent with AB 495 requirements. And then finally, once you have those policies, you want to make sure that you have shared those policies with families who have enrolled children at your childcare. We can jump to the next slide. Okay, and we are going to run through some takeaways. Again, these are big picture things that we just want to make sure that you all remember as you walk away from this presentation. Again, we're sending out the recording and the presentation, but just a few important points. So first is making sure to review and edit your existing policies to comply with model policies, and then again, making sure that families know where to find them. You also want to limit collection of sensitive data from the children in your care and from those families as well. You also need to make sure that you're protecting confidentiality of any data that you are collecting. And then again, stressing that we need to be training our staff in advance so that they feel prepared and supported if immigration enforcement does come to your business. And then helping families prepare family emergency systems and plans so that you are informed about what they would like you to do, and also you can support them in the creation of those plans as well. And of course, the goal is always to keep children safe and supported. We can flip to the next slide. And lastly, we are going to provide some resources. I know Cassidy and Ritu have also been putting them in the chat as well, if we want to flip to the next slide. So just emphasizing again that Public Counsel, we offer free legal support to childcare providers, and we can assist you with drafting and reviewing your program policies to ensure that they comply with AB 495 requirements. So you can if you have any questions about that, or if you want us to review your program policies, you can complete an online intake form at our website, which we can link in the chat, or you can call us at that phone number and for assistance. And then we will also share links to the AB 495 guidance and model policies. I think that actually already might be in the chat. And then if there are any other resources that you might want to look at, you also can look at the allinforsafeschools.org website for resources for providers and families. And you can also request trainings, which is great. And then we will go to the next slide, please. These are a couple other additional resources. I won't run through them all just in the interest of time, so we can keep some time for Q&A. But these are more general resources related to immigration enforcement, the I-9s, which is the employment eligibility verification forms that Ritu was talking about. Again, if you receive an I-9 audit, you want to contact either Public Counsel or another attorney before responding. And then Public Counsel also, we have a couple publications and resources about guidance for responding to ICE for nonprofits and small businesses. And then also some resources about, again, creating those family preparedness plans with those families. And then we can flip to the next slide. And then lastly, we wanted to share some resources regarding rapid response hotlines. I'm sure, as many of you know, there's various rapid response networks within LA and beyond, just so folks can help to either report ICE activity or connect people to detention legal services. So the Immigrant Defenders Law Center Rapid Response Legal Resource Hotline covers a wide range of counties, including Los Angeles County. You can use that phone number there, calling anytime between 9 a.m. and 4 p.m., Monday through Friday, and they can help connect you to legal services for folks in detention. And then there is a link at the bottom of this slide to a list of rapid response networks in California if you don't see maybe your county in the list for the IMDEF rapid response hotline. And then I think I will pass it back to Ritu.
Thank you to all the presenters that have been supporting today. If you could please click on the link that I just dropped in the chat and fill out the evaluation. This is the evaluation of the webinar today. We'd love to hear from you and your feedback. Thank you so much for being here today, just sharing this before we move on to questions. 3 people that respond to the evaluation will be selected randomly for a $50 gift card. And so that is another incentive of responding to the evaluation. We are also sending out certificates of participation. And so please fill out the evaluation and indicate whether you want a certificate of participation to be emailed to you or not. Again, the link is in the chat. I dropped it just a moment ago and I will drop it one more time. And so if you can, either now or after the presentation, fill out the evaluation, we'd greatly appreciate it. Ritu, I'm gonna pass it over to you to close us out with questions. Tahoe,
Yes.
Yeah.
or Cassidy?
Ritu, I can hear you. I don't know if maybe something happened.
Sometimes with the translation feature, it puts you in another room. So that may have been what happened to her. But I can hear you on the English end.
Ritu, there's one additional question of, do the centers have to submit to the Attorney General for audits? Or how do we know yet how enforcement for this law will work, and if there's any issues, if they're found not in compliance yet? I don't see any additional questions. Oh, looks like one more came in, but um, just a reminder that although that PDF of the model policies is very large, and our model policies can be lengthy as well. It does have a lot of answers in it. So especially if you're looking for specific situation you're in, it can be helpful to reference it. And then again, we provided our intake website, and we'll put our phone number in as well.
There is a question in the chat about the board. And I just wanted to clarify in the guidance, there is no requirement that your board of directors has to vote on it and approve your policy. But if that is what your agency does, you may need to reach out to Public Counsel to ask how to handle that, but it is not a requirement in the guidance.
I I just want to repeat what Ritu said. I think if you're in the Spanish channel, you might not be able to hear her right now. But she said in response to the question about if your board is not meeting until August, um, for public counsel, for example, it's not in our bylaw requirements that the board needs to approve this kind of um, policy. So we had our executive team approve it. So if it is the case for your uh, nonprofit or the way you function, you need in your bylaws, it requires board approval. You will need to, if possible, I would schedule an emergency board meeting, is what she advised. And now it does look like we don't have any more questions. Thank you all for such great questions and attention to a really important but dense topic. And again, really, really appreciate you all for being here tonight and for the work that you do. And Andrea, will pass it back to you.
I was just going to extend my thanks as an early educator in the field. I know how passionate each one of you is about what you do and the love that you bring to your classrooms and your homes every day for the children that are there. So thank you for what you do in the trenches. Thank you for protecting your staff and the children and their families. And please reach out to Public Counsel, who will be able to support you, or if you need any other assistance. But thank you for being here today. You show that you are dedicated to what you do, and I look forward to working alongside you as we move to protect all of our children and families.
Thank you, everybody. And thank you again to our interpreters for their hard work tonight and for bearing with us as we worked to slow down.